Network. I'm Heather Hansen, and we have got a full day for you here today. We've been listening to the closings in the Jeffrey Willis case, and the prosecutor just finished his closing and they've taken a break. In the Toledo case, they are getting ready to come back and continue the death penalty part of that case. And we are watching on one of the streams the choosing of a jury in the case against Adam Matos, which we understand will start either sometime today or perhaps tomorrow with opening statements. To help me break all of this down today, we have a fabulous guest here in-house, which is always nice. We have Russ Novack. Russ, welcome. Russ is a criminal defense attorney for many, many years.
Decades plus.
And we've been talking here in the studio about the closing in the Jeffrey Willis case that we just heard, the prosecutor's closing. And the chat rooms across the board are indicating that they feel as though the prosecutor did a very strong closing. What did you think?
I have to give him kudos. He did a very good job. He's very methodical, laid out all his evidence very precisely, very orderly, was interesting, kept my interest even though he only had an audio feed. I was very interested to listen to what he had to say.
And the same, and that's unusual, right? I mean,
Right.
I guess we're getting used to podcasts and maybe a little bit more used to listening to things, but to be as into a closing as you and I both were, given that it was just audio. I mean, there was even times that he was referring to a diagram, and yet it was very clear. He was extremely methodical. And I think that everyone who was listening with us in the chat rooms, I don't think anyone has said, that was boring or he missed this point. And so many times, Russ, in the cases that we've covered, the opinion has been that there has sort of been like all over the place. When there's a lot of evidence, it's really hard for the lawyers not to be all over the place. How do you prevent that in a case like this case against Jeffrey Willis, where there's so much evidence?
Well, I think you have to make it interesting. I think when you have a lot of DNA evidence like you had in this trial, the jury likes to hear the numbers. And I wrote a few of them down. 79 billion times more likely, 47 billion times more likely, 90 quadrillion times more likely that it was the victim's DNA found on the gloves.
Say that again.
90 quadrillion times more. He said it was 90 quadrillion times more likely that it was the victim's DNA found on the glove.
Good morning.
90, I mean, that's an effective...
On October the 23rd,
numbers.
Right.
2013,
Because sometimes the DNA evidence
This defendant,
can be overwhelming,
Toledo,
dry, boring, but using it that way is very
Right.
effective.
I think a lot of times when you do have DNA in a trial, you have to lay a foundation for that, a scientific foundation. And that's the real boring part. I mean, I recall back the first time I actually saw something like that live was during the O.J. Simpson case, many years ago. And I was very interested as a lawyer watching this, but I sort of fell asleep watching it when I'm laying the foundation because it's very, very scientific, cut and dry. But on the other hand, when you're summing it up in front of a jury of lay people, he really brought it home. 90 quadrillion times more likely that it's the victim's DNA found on the glove. And then another thing he said that was a great grabber was that something was 1 in 24, something, but he said that's 24 zeros.
Yes.
So that's really a graphic nailing of the subject matter, and it really brings it home, makes it easy for the jury to understand, and is very convincing.
I loved it. I thought that was extremely effective as well. And I think that in a case like this that we all sort of think is a slam dunk, many people think is a slam dunk, I don't want to speak for everyone, to be as methodical as he was and as hit every point, he hit every element of every crime. Now, did there come a point in time where you started to feel like perhaps this was beating a dead horse, or do you think that he had to do what he did?
Well, it's interesting answering the question as an attorney versus answering the question as a spectator or a layperson, because analyzing it as an attorney, when you're DA, you have to lay out how you proved every element of every charge beyond a reasonable doubt, and he has to do that. But on the other hand, I think, after all the DNA and after reciting the horrific details of the murder and the things that were found in the van, all these different devices and sex toys and so forth, I think the jury at that point probably said, we've heard enough. We've heard enough. But on the other hand, they have to consider, I think all the charges are being submitted to the jury, so they have to consider everything. When they go back to the jury room, they have to sort of match up the evidence with the elements. So it has to be done. And I think, after a certain time, I think I sort of tuned out a little bit because it wasn't like the juicy stuff of the
Yeah.
murder, and when he laid out the elements of kidnapping, well, you have to move the body from point A to point B and so forth and so on. Yeah, he had to do that, but on the other hand, I think the damage he did to the defense case was already done at that point.
Yeah, I mean, it's going to be fascinating to see what the defense is going to argue, or
Yeah.
hear what the defense is going to argue, because this is a case that I just feel as though, they tried to bring Kevin Bloom in as a potential defendant. This morning while Jesse was here, we had some great testimony regarding his alibi and the fact that he has a really strong alibi and no DNA. I mean, there's just a million things to sort of take away that possibility. We had a guest here, I guess on Tuesday, who talked about defending cases like this and trying to say it's not enough to say that my client probably did it. It has to be proven beyond a reasonable doubt. And do you think that that's what you try to do here?
That's exactly what you have to do here. I mean, when the evidence is strong, when you have DNA, which juries, for the most part, like. They like this stuff. They're sort of fascinated by it or mystified by it, but I think most of the time, if you get the right jury, they'll accept it and they'll buy it, and then they'll use it against the defendant. But when you have what we like to call a dead case, a loser, I mean something going in where it's like, you sit up at night and you scratch your head, how am I gonna do this? How am I gonna go in there and make an argument and try to convince people that despite a mountain of forensic stuff and a mountain of eyewitness testimony and gory physical evidence, how am I going to win this thing? And the answer to that is, it's not enough. The answer to that is that you have to argue to the jury that the people have the burden to prove every element of every crime beyond a reasonable doubt. And that's a heavy burden. And a lot of times in openings and summations, the DAs will tell you that. They'll say, well, we have a really heavy burden, but we welcome it.
Right.
And it's your job to convince the jury that the prosecution hasn't proven every element of every crime beyond a reasonable doubt. And once you look hard enough at the evidence, and once you really study it and break it down, when you're not panicking because you have to go into court the next day, but once you sort of get a detached analysis, most times you can find something to rip apart.
And let's talk about that freaking out, because I think that one of the things that when I'm trying a case, I really worry about my credibility with the jury, because I don't want to lose credibility on any one point, because I'm afraid I'll lose credibility on every point. And so when you're preparing the night before, are you really working to find that thing that you can credibly pick apart so that you don't lose credibility with the jury on the things that are less strong for you to pick apart?
That's right. You have to pet your arguments, and your case, if you're going to put one on, has to pass the giggle test. And you can usually come up with something that will, most of the time. I mean, all of the time. I could say all the time you will. And some things have a greater potential, and some things have a lesser potential. And the best way to do that is to talk to somebody who's not a lawyer. I mean, talk to the guy who sells you your coffee from the cart, or talk to the guy where you drop off your laundry, or talk to the woman who you see in the elevator every day. And you run it by civilians who are completely detached and removed from what you're doing as an attorney. That's a really effective way to do it.
I love that. And it's, in fact, one of the things that I love about working here, because I'm hearing from the chatters in the chat rooms, they see things in a different way than someone who's practiced for 20 years might see things. And I do the same thing with my assistant at work, and with the different people who work in the file room, and people that you just are friends with. Try and run the different things by, because they do come up with some great questions that you otherwise, and issues and ideas and thoughts that we lawyers sometimes don't see the forest for the trees.
That's true. And here's an interesting and a true story. The last trial I did was back in February, New York Supreme Court. And it was an assault trial, an assault on a policeman with a pit bull.
Oh, wow.
And during the trial, one of the court officers would sort of whisper in my ear, the jury liked that, they didn't, or that was stupid, or don't say that, or don't go there again. So it's really important when you're conducting a trial, whether you're a defense attorney or a prosecutor, to really get feedback as to what you're doing, because a lot of times, look, lawyers are, especially trial lawyers, are great show people, and you tend to believe your own stuff, so to speak, and it's really important to get feedback so that you don't get lost in your own head and get some lay people who are not connected, who are more impartial to sort of call you on your stuff.
Yeah, I agree with you wholeheartedly. And sometimes you've got to put the ego aside to let those people call you on your stuff. And you've got to do that for your clients as well.
Right.
That's actually a good segue into the Toledo case. Because one of the things that happened in Toledo, and guys, if you have that little bit of roll of Toledo with the hand signals that he was making, I think it's 96, there was a point that he was making some signals with his hands. As we see there, he's sort of moving his fingers around, nothing glaring. And yet the judge sort of told him that to stop making those hand movements and to stop with being so, fidgety. Now, that's one of the things we were talking about, that and how we've got to make sure that we do our best to talk to our clients about the fact that they are always on stage, always in the spotlight.
Right.
How do
That's
you
true.
handle that?
You really need to have what I call a come to Jesus moment with your client, like right before you start picking a jury. I mean, a lot of times, as you know, doing trial work, there's a lot of dead time, and there's a lot of waiting around and kind of doing nothing and hurry up and wait sort of things going on. But it's very, very important to have the jury like your client. And it's very important to have the jury like you, so you get a transference of like me, like my client. So you want your client to look like and actually help you do your job defending him. So it's important that the jury see that your client remains attentive, looking interested in what's going on, helping you by passing you notes or writing on a pad.
Yeah.
I mean, a lot of times it's happened. You have to throw a client elbow, like, "Hey, wake up!
Yes.
Hey, wake up!
Yeah.
You know, this may be boring to you, but the jury doesn't want to see you sleeping."
Well, and that's the thing. I mean, they know their clients, people, anyone who's testifying knows that they are the subject of everyone's attention when they're in the witness box, but less so when they're sitting at the table. And yet they are always being watched, and it's really important. I noticed even after Toledo had been told by the judge not to be moving his fingers, he was yawning and moving around. I think we both noted that, and that's dangerous.
It's not a good look. It's not a good look. I mean, you tell your client the minute a trial starts, you are being judged. From the minute that jury walks into this room, they are judging you, even if you never say a word.
That's right.
You are being judged, that you're being watched. Every twitch, every eye roll, every time you sort of say mouth, no, not true, or he's a liar.
Right.
Or, sort of your back, you literally, I've seen people get their backs up. So
And
you
it's
don't want
hard.
to show that. You don't want to show that because one of the things about doing conducting a criminal trial as a defendant is most times the defendant doesn't testify. In all the trials I've done, it's happened twice, and luckily it worked out both times. But you don't want them testifying. So the other 99% of the time, you don't want the jury knowing anything about your client other than he's presumed innocent, because that way you can meld things around that presumption of innocence the way you want them to meld.
That's right. It's definitely, you can create the story the way that you want it
Right.
to be created. We'll come back to Toledo in a second, but I want to just finish up with Willis, because we're talking about the fact that this is a death penalty case, and all of our cases are that we're handling right now. How do you handle those types of closings differently?
You have to remind the jury that this is high stakes. This is the highest possible stakes trial that you're ever going to sit on, that you're ever going to see, that you're ever going to be a part of. You have to be careful. You can't joke around. You can't have a light tone. You really need to focus. It's really, really important to focus and to remind the jury every step of the way what the stakes are here and how important things are.
Let's talk about the Adam Matos case, because that is another case that is also a death penalty case, and they're in the midst of jury selection right now. And reminder to those of you who are watching, if at any point in time you want to watch one of the other trials, you can always go to the upper left-hand corner of your screen, hit Live Trials, and you get to choose what you're going to watch. We are streaming the Adam Matos jury selection. We are streaming Toledo, and I believe they're back in court. If you're looking at Toledo, it appears as though there's a prosecution expert being called out of turn, another doctor, to counter the doctor's after this morning, and we'll go there in just a bit, but we wanted to give you some analysis. And during jury selection, we were talking about this while we were listening to Willis. We both love jury selection. Why do you love it?
I like it because you get to talk to people directly. And I like it because I like the theater of it. I like asking people questions and finding out what they think and trying to get people to speak. And I think this is the most important part of any trial, is picking a jury, because you want the jury to be exactly who you want it to be. You don't want the prosecutor to have more of his picks on the jury. You want to get as many clean picks who are going to side with the defense as possible. The prosecution has a different sort of view of it. They say they want a fair jury. I, as a defense attorney, I don't want a fair jury. I want a biased defense, biased jury.
Well, yeah.
A defense attorney, I don't have the same sort of considerations that a prosecutor has in picking a jury.
Yeah, for me, it's always interesting to try to do. I majored in psychology, so I always have that psychological, like, why are they saying this? And are they trying to get in? Are they trying to get out? Do they have some sort of a axe to grind with one side or the other? It's also not such a stressful day for me, and oftentimes, especially where I practice in Philadelphia, we don't actually start openings until the next day, so it's a day that's not going to be enormously stressful. But if you're defending Adam Matos, Russ, today, they've been picking a jury, I think I know that at least today and yesterday, I think they started on Monday. What kind of a jury are you trying to get? Because it seems as though there's a lot of evidence against him.
I want smart people. I want very smart people. I want college-educated people. I want professional people, graduate, post-grad degrees. And those kinds of people are hard to get on juries because they don't seem to make it past the first round when the judge asks them questions about what they do and reasons why they can't do it.
Right.
So it's hard to get smart, well-educated people. So you try to get as many of those as you can, and you try also to get people with a lot of common sense who, when you start picking apart the flaws in a prosecution's case, can sort of latch on to your argument. And what I always tell juries in my summation is that if you agree with something I said during my summation, take it back into the jury room during your deliberations and say, well, Novack would say this. And hear my voice and repeat it back to the jurors who disagree with you. And I think, and that's all common sense.
How much do you worry, though, about those very strong personalities? Because you talk about, taking this back into the jury room. In the jury room, there's going to be some people who are more vocal than others, some people who are more aggressive. How much do you worry about one person sort of taking over and being the boss of the jury? And if that person's not going to be on your side?
Those are the people I worry about.
Yeah.
Those are the people I worry about. Of course, I want the strong personalities to be defense-oriented, but there's always someone. There's always a person who's very pro-prosecution, although they try to mask it. And those are the people who you try to sort of weed out during the jury selection process. But you can't get all of them. And you also, what your viewers will know from watching this a lot, you only get a certain amount of challenges, right? So you get in New York, and I'm sure it's the same in most places, you get an unlimited amount of challenges for cause, which are pretty hard to get.
Yeah, let's go a little bit deeper on that.
Okay.
For cause. Let's talk about what that has to be. It can't just be because I said so.
Right. The cause is this case is somebody couldn't be fair and impartial because they're related to a police officer. That's a classic one.
Right.
And then when they say that, the judge will jump up, or the DA will come back in her round and say, well, just because your father-in-law is a police officer doesn't mean you can't be fair and impartial. And they'll say, I can always be fair and impartial, even though every Thanksgiving the brother-in-law of the police officer is raging at the table about the dirtbags he locks up every week. So you have to sort of weed those folks out.
Well, and what happens, let me just interrupt you. What happens there is, they'll say I can't be fair and impartial. You're like, oh, good cause in your mind. But then the other side tries to rehabilitate that person and say, oh, but you could be fair and impartial if the judge asked you to be fair and impartial. And then it's sort of a battle.
And they always say yes.
Sure.
And those are the people who, if you can't get them for cause, you keep in your back pocket and burn a peremptory challenge on a person like that. A peremptory challenge.
What you try to do is you try to get them knocked for cause. You try to get the judge and the other side to say, look, this person can't be fair. They've said so. If you can't, then you've got to use one of your challenges, as you were saying.
You got to burn a peremptory challenge on that person, which is not the preferred way to doing it because you only have a finite amount of peremptory challenges. Now, in a capital case, you probably have a lot more than you would have in your other sorts of felony cases, like a robbery or a drug sale. But, and the judge can also, and I think they probably would in the capital case where the stakes are so high, at least in New York, you can always increase the amount of peremptory challenges that you can grant.
Which is probably one of the reasons that it's taking so long.
Right.
Because the more challenges you have, the more potential jurors you
Right.
have to have.
Right.
And it's interesting that you pointed out that sometimes the jurors that you most want end up being the ones who no longer are serving. They get out for what's often called hardships, where they say, I don't get paid. A lot of times judges will not make someone serve if they don't get paid, or if they have a prepaid vacation, or if they have child care or elder care issues. But it's interesting, one of the things that I always say when my clients talk about the juries and the jury not really looking like their peers necessarily, I say that this is the importance of serving on a jury.
Right.
So many people talk about, well, this doesn't seem fair, and these jury people don't seem to be of a varied swath of the United States population, but that's because a lot of people try to get out of jury duty, and it really is an important thing that we all do it.
Now, it's an interesting shift change for me doing this for as long as I have. But when I first started doing this, when I got out of law school in '83, I worked in Brooklyn, and the jurors were pretty much either housewives, people who worked for the phone company, people who worked for Con Ed. That's pretty much it. And retired civil servants, school teachers, so forth, postmen, post office workers. A few years ago, the Chief Judge of the State of New York, Judy Kaye, revised the jury selection system. They did a lot of study, and now in Manhattan, where I practice now, everybody goes. And the juries are more diverse. The more diverse ethnically, the more diverse economically, the more diverse racially. And you're finding now a lot more people with college degrees, and you're also finding now that people are a lot more vocal expressing their distaste for certain things.
Yes. Yeah, I wonder if that's a function of our politics and online and social media and all those changes.
People are very vocal about what they are willing to tolerate and what they're not willing to tolerate. And also, what's interesting to me, and the judges always tell me you can't consider that, for instance, I try a lot of drug cases, and one of the things that's become a recent phenomenon watching not only my cases but my colleagues' cases is the question is asked by the prosecution or by the court, what do you think of sitting on a drug case? And jurors almost, I don't want to say almost universally, but enough to notice, have said they think the drug laws are too harsh, and why is anybody on trial for having drugs, and why is anyone on trial for selling drugs? So it's been a really big change in the thought process of the general population.
Yeah, it is interesting to see how opinions shift and culture changes affect the juries as they go. We're going to take you live in just a minute back to the Toledo case, because the prosecution has put on a witness to counter the defense expert that we heard from this morning regarding the medical testimony about the brain damage that Toledo allegedly had that would have caused him to be unable to sort of control his actions. Before we take you live to the courtroom, though, I want to get the benefit of Russ's ideas on this, because we were talking about this as well. What do you think of this first, just the idea of talking about brain damage as a part of the mitigators, and what do you think of the timing of it?
Okay, so the first part of your question, I think it's really important, and I think the testimony should be allowed and should be considered. This is a decision that is almost impossible to make, and it's a decision with an irreversible consequence. You're talking about a death penalty. You're talking about sending somebody, in Florida in this case, to the electric chair. Before that decision gets made by the person or persons, in this case it's a jury making the decision, the jury or the finders of fact, the decision maker, needs to know everything. No stone, no matter how big, how small, or seemingly insignificant, should be overturned. And why rush? Why push these proceedings along? What's sort of amazing to me, and this is something we talked about before we went on air, how quickly this decision gets made. Mm-hmm. The trial was over, Friday afternoon, if I'm not mistaken, yep. And they started considering the death penalty issue Tuesday.
Yep.
So, which sort of left the defense and the prosecution also pretty much not a lot of time to get experts, and not a lot of time to think about this and shape their arguments. And I think what further confounded this is that Mr. Toledo said right after the verdict came out, I don't want any mitigation. I don't want a mitigation hearing. Just send me up to the chair,
Yeah,
basically.
and that's what happened here.
And
I mean,
that for a defense attorney is mind blowing.
right.
Thankfully I've never had a case like that. But look, we fight, and we don't take kindly to towel throwing,
Right.
especially when it's your own client. But yeah, so I think it's important to consider it. I think it should be considered. I think both sides should be given every possible amount of leeway and consideration in terms of who they want to put up on the witness stand to talk about mitigation. I think it's critical. This it's essential to a free society and the integrity of the judicial process that they be allowed to do this.
Well, we want to take you back live to the courtroom because this particular expert is actually very effective in countering some of the defense's arguments about the PET scans and the brain damage and testifying in a way that I think that you'll enjoy more than maybe some of the doctors we've seen in the past. Hopefully we'll have the opportunity to have Russ Novack back again before he has to leave, but just in case we don't, we want to thank Russ for being here with us and your insight. Right now we're going live to the Toledo courtroom.
The program he used showed that those couple of areas were a little different than another area. And that's why the program made them black. But there's two or three things. The first is, there are too many normal programs out there, and there's variation, and what does a little difference between 2.5 and 2.6 mean? So that's number one. Number two, again, when I said statistics, the bell-shaped curve says that if you're 2 standard deviations above the mean, it includes 67% of people, and if you go 2.5, you get 97% of the people. There's still the other 3%. If you're doing a study and using this kind of program, you don't really use those kinds of statistics because you're not asking a specific question. You're not asking, is there something the matter with the frontal region or what? He does that study, and his report indicates brain abnormality. Well, if you do that, there's a Frenchman, and his name is Bernoulli. His statistics say that when you use that kind of analysis, rather than trying to answer a specific question, but looking in general, the standard deviation values change significantly, and you have to get up to 3 or more before you can say something is worrisome. Okay. And again, I don't like to use the word specifically an abnormality, because in these circumstances, we're looking at variations of metabolism.
Now, and again, going back to those slides, we've already talked about how clinicians in the field do not use the rainbow scale, the colored scale. You talked about the grayscale. Are you going to see those black dots if you're looking at this in grayscale?
The black dots are something that is put on there by the program to say that the region of interest that I was looking at has a certain standard deviation. The program could put black dots or colors or anything, and if you're looking at a grayscale image, it'll put an area black or green or whatever you want it to.
Okay. And that's the person who's conducting the analysis. He plugs whatever it is he's looking for in, and it will produce that result. Is that right?
Well, you run the program, but somebody writes the program, and it'll run. Doesn't matter who runs it. Let me just mention one other thing. Dr. Wu mentioned that he chose some place to measure. Let me just leave it at that. There's a lot of complications in how you use these kinds of statistical programs.
The bottom line is that this is reaching the conclusions that he is reaching in this particular case is not, while there may be research going on in this field, it has not been validated enough to be able to call these kind of conclusions reliable. Is that correct?
Well, that's correct. You don't know what to do with something you find, and if you don't know what to do with it, you can't use it. You can't read the history into the image. You get paid to do the image because it provides independent data. So you see something, we teach our residents, and we all make observations, then you synthesize your observations, and you come up with a differential diagnosis. And that differential diagnosis is based on your image. And we just don't know enough.
Anything that you saw in your review of these PET scans indicate that the defendant would have any kind of loss of impulse control?
The answer is no, because the study was normal. But it's my contention that you don't use these studies for that purpose, because it's not been validated. So no matter what you see, you shouldn't use it. I mean, if it was part of a research project, and people are doing it, they are getting prisoners, they're getting people on death row to volunteer for studies, and they're getting football players with this chronic traumatic encephalopathy. You can't diagnose that on a scan. But now they're trying to do images over time in all of these patients. They'll see which football player becomes more violent, which one dies of traumatic encephalopathy, and then you'll be able to go back and hopefully do a scan when a kid wants to play football in college, and do it at his first year and every year thereafter. Say, you know, your brain's taking a lot of hits, you better stop playing. We're not there yet.
You have a moment, Your Honor.
Thank you. Cross-examination. Yes, sir. No.
All right, ladies and gentlemen, this is a sidebar in the Toledo case. The expert who just testified was an expert for the prosecution being called out of order. Likely, don't you think, Russ, because of scheduling? It's really hard to get experts to be scheduled so that they all fit in the perfect order that you'd like them to.
Yeah, that's true. I mean, we do that quite often. It's not unusual at all.
Now, it seems as though, you know, a lot of times there's this issue with doctors where they sort of talk over the jury's head, but it seemed like this doctor was really communicating well and effectively to the jury and keeping things pretty simple.
Yeah, he definitely had a zero egghead factor. He was fine. He was a good witness for them.
Yeah, and now getting ready for cross-examination, it seems as though the defense may have a difficult time with him.
Well, it's difficult cross-examining experts as a prosecution experts as a defense witness, because you really have to know the science, and you really have to educate yourself or have somebody educate you as to the best way to attack the scientific foundations of his expert opinion. So and a lot of that becomes boring. You have to, you know, one of the things you're allowed to do is impeach him with what's called a learned treatise, which means you have to refer back to some scholarly article from a journal, and say, isn't it so that in such and such an article in the Journal of American Psychiatry, Dr. Jones said this. And then you can end up getting into a debate with a witness over what was contained in a journal and what it really meant. So it's really sort of, you have to do it. You have to sort of knock down his the basis for his opinion.
Hold on, I'm interrupting you, Russ,
Yeah.
because I think that they're going to take a break. So we're going to come back live in just a second here so that we can look at the camera and not just talk to it.
Okay.
Okay, welcome back to Law News Network. I'm Heather Hansen here with Russ Novack, and we've been breaking down the Toledo case, and now they're taking a break. It seems as though this expert, Dr. Holder, is actually done and not going to be called back, and so now we're waiting to see what is going to be the next witness. But you were just saying, Russ, about how cross-examining these medical experts can be a different animal. Tell us why.
It's very technical because, as I said before, you have to attack the underlying assumptions in his opinion, and those are, if he's good, those are scientifically based, and you really have to educate yourself as an attorney as to the science.
Yeah, and that means that's a huge endeavor. That means
Right.
reading, as you said, reading journal articles, and depending on the type of expert, I mean, you're reading, you can be reading some really in-depth neurological
Right.
or articles
Right.
that are difficult to discern. And this is one of the things that I've always found most challenging about my job is learning that stuff on the level that the doctors write it, and then trying to break it down to a level that everyone can understand, everyone in the courtroom can understand it.
Right. I mean, you really have to try to convince the jury that what you're talking about isn't some esoteric scientific concept. You have to make it real. For example, in a drug case I defended once, the issue was how much the drugs weighed that were sold. So the weight of the drugs was something like 1/2 of a gram. So how do you, and a gram's a very, very tiny infinitesimal thing, so what do you know that weighs a gram? So I had to pull out of my pocket a packet of Sweet and Low to show to the chemist that this is about a gram, isn't it? Of course she wouldn't agree, but that's a story for a different day.
Right.
So you have to make it relatable.
And that's
sometimes it's easy, like a gram, a gram's a pack of Sweet and Low. Other times when suppose it's like an automobile accident, and you talk about the velocity of the crash, it's basic, Newtonian physics theory, it's almost impossible.
Yeah, it's so funny that you say that, because I had a case one time that they were talking about blood loss, and the attorney on the other side, I will never forget this because it was so effective. The amount of blood loss is measured in cc's. But he had equated that to, and he took a 2-liter thing of soda and filled it up as many cc's and actually showed to the jury.
That's great.
Yeah,
That's what you want to do. That's great.
Right. Analogizing in ways that are something that we deal with every day is extremely effective, especially when talking about this tough medical stuff.
Right, I agree, totally.
Now, what types of other witnesses do you think we'll hear from the defense? We've heard from this medical witness that doesn't seem to have really knocked the socks off of anyone that saw him, but the defense is still putting on their mitigation witnesses. What types of things do you usually see in those situations?
Bring in his mom. Bring in his mom.
Right.
First, bring in his mom, don't kill my boy. That's pretty much it.
Yeah, it's difficult. But then when the mom comes in, how do you cross-examine her at all?
You probably shouldn't.
Yeah.
You probably shouldn't, because there's going to be a summation phase when the DA can argue. Look, of course it's his mom. It's the first thing any mother would say.
Yeah.
And it's also good. It's also good for the defense, because if you bring in the defendant's mom, he doesn't seem so bad. He doesn't seem so bad. Even his mom loves him. His mom hasn't turned his back. Turned her back on him. So that could be very effective. You going to have to bring in people who've known him a long time to give pat the dog on the head stories. He's always been a nice person. He walks my dog. I trust him with the dog. You have to unpaint this guy as a bad guy.
It looks like we're coming back. I do want to note one thing that our trial producer Kathy just pointed out to me that I think is interesting. That break was to allow, and we're not quite back live, and as soon as we are, we will take you there. But that break was to allow the defense attorneys to confer with their expert before cross-examining the prosecution's expert. I've never had a judge give me a break to go talk to. It might happen, the break might fall at that point. But have you ever had a judge give you a break so that you can go talk to your expert? I think that's unusual, isn't
I've
it?
asked for breaks, but I don't tell the judges what I need them for.
Yeah, it's.
You can get a lot of mileage out of a bathroom break.
That's right. You can certainly say,
Right.
I've got to. Hopefully, it's not right after you've had a break, but you can
Right.
certainly say I've got to use the facility.
Well, look, this is a death penalty case, and the
That's
penalty
right.
phase of a death penalty case, if you most judges would grant you that. I mean, they don't want to get reversed because you didn't reverse or something like that. I mean, this case is going to be appealed, obviously, to probably the highest court in Florida, maybe even to the U.S. Supreme if they can find a way into it. So you want to give the benefit of the doubt to the defense, especially in a case like this. So I don't find that so unusual or so off the norm.
I think your point is well taken, that you don't usually say that's what you want the break for. But if you do say that in a case like this where it's a death penalty case with such huge things weighing in the balance, it certainly makes sense for the judge to allow the defense to do what they want to do. Well, they've had their opportunity to speak to their expert, and we'll see how well that helped them, because we are back live in trial and we're going to go straight back there.
Okay.
Thank you so much. Everyone be seated. Cross-examination, Mr. Nielsen.
Good afternoon, sir.
Good afternoon.
I have some follow-up questions to your testimony. Now, you talked about the use of PET scans for different areas that didn't sound to me like you had much of a problem with. For example, tumors or cardiology areas for scans and stuff. You said that's acceptable in your mind?
Yeah, I mean, it's not just my mind, it's the community, et cetera, et cetera. There are some tumors that it's not as good for, but in general, oncology is the major area of using PET scans today.
Okay, and you said it was good at detecting differences between scars and actual tumors and things like that, correct?
Yes?
And in Alzheimer's patients, trying to find or looking for the source of where the seizures are coming from? I mean, where the Alzheimer's is coming from?
Alzheimer's, yeah, you're looking for patterns that have been established based on, again, the autopsy results that have shown where these amyloid plaques get deposited and which parts of the brain are involved, and then you divine it.
All right, now you said that your business is, your work life is not just dedicated to working involving PET scans. You said that you do some consulting for drug companies. Is that correct?
Yeah, most of the consulting I do with drug companies deals with imaging, whether it's they're developing research protocols to submit to the FDA or for approval of a trial. I have developed atlases when a new product and new technique comes along, how to teach people how to interpret it.
So, sounds like you're wearing multiple hats out there in the business community. Is that fair to say?
Well, I'd rather call it the medical community because everything I do is based on imaging.
Okay. All right, fair enough, sir. Now, you did talk a little bit about the development or the evolution of these type of medical instruments. And let me ask you this, if Mr. Toledo is 36 now, and he was 10 or 9 when he first started having these seizures 26, 27 years ago, these PET scans machines were not very common, is that correct?
That's correct.
And so if back in the day, when Mr. Toledo would have been in the hospital for some type of head injury or seizure or something to that effect, it would not have been normal practice to refer him to a PET scan. Would that be fair to say?
That's correct. There are other imaging that was
Understand.
available, but the PET scan was not commonly used 26 or so years ago.
All right. Now, you've told us that in your opinion, you've seen the scans from the imaging center, the opposite of Dr. Wu's conclusion where he said they're abnormal. You said under record that your opinion is they are, quote, normal, correct?
That's correct.
All right. And would you agree that just like all of us, you are human and subject in your own world and even with your experience to be incorrect? Is that a fair statement?
I used to be perfect. I'm not perfect anymore.
Touche. All right. And I think you indicated that the database of the, quote, normal brains and stuff that you're aware that Dr. Wu was using or uses is, in your opinion, older, but you do agree it is accepted and used in practice still today, correct?
As far as I know, it's not sold anywhere, not approved by the FDA. In his report, he didn't say what program he used. He only showed two isolated regions rather than a full printout. And sometimes on those full printout, it'll say by CenterMed, that's one of them that's approved. So I shouldn't have said, I just don't know what he used, but from some past interaction with Dr. Wu and reading about what he has done, all his publications, I think he's using this database that was developed a while ago in California.
Okay. And you know, in addition to the, you described that visual analysis, there's also some new modern software that's utilized in the analysis too, correct?
For certain specific things with certain limitations, yes.
Okay. And you believe then that you indicated you disagreed with those blackened images produced by the computer software. Is it your opinion also that the company that developed and uses that computer software is wrong or incorrect with what they're putting out there to the medical community?
No, let me just say this. Again, I don't know the software that your company that you're referring to, so I don't know their reputation as I do others. What I was saying is there are some black dots which on the image that he showed said that it was 2.5, I don't remember the specific, and I said, in my mind, I don't know specifically the region that was chosen, the region of interest that he used, as opposed to a voxel-based analysis. And as a result, the significance of that is very dependent on the software program used, etc. And it's okay in a potential research project where you're looking at groups, but you can't apply it to an individual patient. Not enough research, not approved, etc.
In your opinion?
Yes.
And you do seem, though, to be consistent in the fact that on some uses of this machine, it's fine and acceptable, but just not the way it was used in this case.
Well, everyone knows that. A Volkswagen is a great little car, but you're not going to run it in the Indianapolis 500 or the Daytona 500. I mean, a PET scanner is a great tool.
All right. You said that it's used even as recently as what you hear for sports fans out there about these ex-players and their concussion studies. It's used in that field, Alzheimer's and other fields.
Again, in Alzheimer's, the development of the use of PET scanners in Alzheimer's was in the U.S. by UCLA. There were several centers, one in Germany, one in the Netherlands, in which they followed patients for years. They did PET scans every year for up to 10 years. Then they did autopsies. After they did that, then they could go back, look at the scans, try to figure out a program to create a normal database using those patients as the Alzheimer's patients, and then tried to get a normal database. And as you can imagine, that's why they're trying to standardize it. Every database is different. Let's say I think I'm normal. I think you're normal. You may have some quirks. I have some quirks. So we're all a little different, and that goes into a normal database, if you will. but it's still dependent on the kind of people that are in the database. So that's why I'm saying research in a single laboratory, fine, but across the spectrum and in a clinical patient, and this patient may be forensic, but he's a human being, and you can't use it for that.
Okay, so these doctors and experts that are around the country working on these bigger cases like this NFL lawsuit and stuff, they're just going down a rabbit hole, they're wasting their time.
Again, the use of the PET scan in football players is research in progress. The people who are doing PET scans, if there are, I'm not familiar with a specific court case that's using a PET scan. But what I would tell them, as I've told you, you cannot use this to make a diagnosis because there are no established patterns, there are no sensitivity or specificity. You can't use it. Now, you can use it and show color pictures for whatever reason you want to.
All right, well, that segues right into what I was going to ask you. You talked about this gray scheme, and in your opinion, you said that's the better way to go, right?
Yes.
All right, are you aware that Dr. Wu, in addition to the color scans, also does a visual with the grayscale? Do you know that?
Well, if you tell me he does, I will believe that.
Okay. And would you agree, sir, that a certain way you can do it with the grayscale? We've seen the color, but for courtroom presentations, would you agree that the color is better suited to explain perhaps to lay people what's going on with these images? Do you agree with that?
No.
Okay. All right, did you measure and quantify any of the areas of damage that Dr. Wu has identified on the brain scans of Louis Toledo's brain?
No, I just received the brain scan this morning to look at it. I had seen his pictures a little earlier.
Okay. Did you take Lewis's known scan and yourself compare it to any of these normal databases that you were talking about?
No.
Are you aware, sir, you talked a couple different areas about what you believe to be the still developing science, and perhaps this scan is not as widely acceptable. Are you aware that many textbooks do accept the science of brain injury being detected from PET scans? And are you familiar and have you read Tchaikovsky's book on this subject, Cerebral PET SPECT Imaging?
Yes.
Right. You know there's a third edition of that book at this point?
Yes.
And you are aware, sir, that there is a large section of that book dedicated to what the author says is the usefulness in clinical and research acceptance of PET scans and brain injury.
Notice you said clinical and research, and I will continue to tell you that when you read every article in the literature, they all say may be helpful, more work needs to be done, larger groups need to be evaluated to determine its efficacy in clinical and research applications.
Okay, well, that general definition and description you just read, that could be applied to many, many areas of medical practice that are used and accepted all over the country. In hospitals and doctor offices today, they're still developing and getting better at things, aren't they, doctor?
You'd have to be specific.
All right.
As you know, Medicare does efficacy studies on new procedures. They will pay for a certain number, for example, and acquire data. And when I say a number, it's a big country. They may do 50,000 or 30,000. And then they say the results don't allow us to say this is efficacious.
All right, let me ask you this. Have you read Osborne's book, used by many emergency room physicians, that also discusses the clinical acceptance of PET scans?
No.
Would you agree with this, doctor, that if someone has brain damage, it would show up on a PET scan in the frontal lobe area as decreased metabolism. Do you agree with that?
I'm sorry, would you repeat that question?
If someone has brain damage to the frontal lobe and they are on a PET, and they get a PET scan, it will show damage to that frontal lobe area with a decrease in metabolism.
And how do you know they have damage?
I guess the guy had a spike drilled through his head, sir. I'm just
If you had a
asking.
spike drilled through your head, that's why we do PET CT scans, because we would see the area in the brain that either had an area where, like, you core out, if you're getting ready to plant a bulb or something, and you see a hole, there's no brain there, so the PET scan would have an abnormality. There wouldn't be any metabolism there.
Thank you. Are you familiar with non-convulsive seizure disorder?
Yes?
And someone who has a long history of seizures, like Mr. Toledo, you agree that he could be suffering from that disorder?
That's a clinical question which I don't feel competent to answer.
Do you agree that stress can set off or increase the seizure disorder that people have?
I'm not an expert in that.
Do you agree that the statistical analysis described by Dr. Wu is a more sensitive way to analyze a scan than a visual analysis?
I think it's potentially complementary, but again, we're talking about a research use. In a clinical sense, there are no data of sensitivity or specificity in the things that Dr. Wu presented.
All right, let me ask you this, sir. Did you ever meet or speak or talk to Mr. Toledo?
No.
I don't have any other questions, Your Honor.
All right, thank you. Any retract? All right, thank you. May the witness be excused, state? Yes. Defense? Yes. Yeah, thank you so much, sir.
Thank you.
Let me step down. All right, folks, we're going to have to take, I know, through no fault of anyone. I'm pushing hard, so I'm messing up the schedule. No good deed goes unpunished. So we're going to have to take a short break. It'll be roughly about 15 minutes or maybe a little bit longer. Take them back there, yeah.
Welcome back to Law News Network. We've had yet another break in the Toledo case and another opportunity to talk to Russ before he leaves us for the day. So in total, you were paying some close attention to Dr. Holder as he was testifying. What did you think of him as a prosecution witness?
Thought it was very effective. I think the defense couldn't shake him. He was very concise and definite in his responses. And what he basically told the defense is your expert was
Wrong.
wrong. He was wrong.
Right.
I don't want to say your expert was full of it, but basically he said there's not enough data to support the points your expert was trying to make. He basically shot the defense, this Dr. Wu, down.
And you know what? The other thing that was, I agree with you. I thought that he was very effective. I thought that the cross-examination did not touch him. He's also, you pointed it out, and some of the chatters pointed it out, he looks a lot like the character from the movie Up.
Right.
Which makes him very likable.
Right.
And that's hard to overcome.
Right, he's coming out with a head start. He has a head start coming out of the gate. He's likable, he's approachable, he seems to be not an academic all the time, although he is an academic when he needs to be to counter what the defense is asking, but in terms of the points he tried to make and the things he had to make, that the science is unproven, that there's no connection between what you see on a PET scan and someone having a seizure disorder. Mm-hmm. And the science that the defense expert is arguing is basically incomplete and untested. I think he was very effective.
And it's interesting, I want to talk a little bit about the science, because he mentioned chronic traumatic encephalopathy, CTE, which we've heard so much about with the various football players. And we here at LawNewz have seen a lot of cases involving people like War Machine, who was a world fighter.
Mixed martial MMA fighter.
Exactly. And then Aaron Hernandez, who obviously had
Right.
played, and then even looking back at OJ. The science, the medicine seems to not be there. But do you think in time, similar to our DNA evidence that we rely so heavily upon in court now, that we're going to be seeing more and more of these brain scans as a defense to explain the behaviors of some of our criminal defendants?
I think so, because what you try to do in certain cases when it's relevant is to say the defendant did not have the intent to commit the specific crime, didn't have the intent to rob someone, didn't have the intent to have sexual intercourse without the victim's consent, and so forth. So how do you prove that? You sort of look at the person's actions and what they say, and any sort of things, extrinsic things that anyone else has to say. But now, eventually, I think the science will develop to a point where you actually can point to like an area of the brain, say, look, it didn't light up.
Yes.
And when it doesn't light up, that means he doesn't have the intent to do X, Y, Z. I think that's probably several years down the road, but I think I agree, that's the direction that we're going to head.
Well, and that was that doctor's point. The medicine is not there yet. The
Right.
science is not there yet.
Right.
But it may well be. And it seems as though, I mean, to sort of go off on a little bit of an aside, it seems as though right now CTE is diagnosed after death. If they can come up with those types of studies, not only would it be helpful in court, but it would also be helpful in trying to treat and prevent those types of things.
It'd be a great thing, but like a lot of great things, like the internet, it cuts both ways.
That's right.
It cuts
That's
both
right.
ways.
And that's a really good point, because in so many of these cases, the medicine that you think helps you, there will be some expert on the other side that will point out the ways that hurts you. And so you just have to have the better expert, the stronger medicine, the stronger cross-examination, and hopefully be able to use that evidence to your benefit.
Yeah, the point, the takeaway from the expert testimony we heard today is that you really have to be prepared from a lawyer point of view, whether you're a prosecutor or defense attorney. You really have to know the science, and you really have to study, and you have to. Most of the time, you end up teaching yourself, and hopefully you get it right. But it's really another part of the job that's certainly very interesting, but also the most maddening. One of the most maddening things about it.
It's definitely one of those things that when I went to law school, I didn't realize I'd be learning so much medicine. And you learn a lot of medicine as you prepare for damages experts, or if you do medical cases. It's certainly a big part of your practice.
You learn a lot. I mean, what I tell the younger lawyers that I train, to be a very effective trial attorney, you have to know a lot about a little.
That's right. That's absolutely the case.
And you never know what you're going to have to learn about how drugs are packaged, for example, or bite patterns, or what blood spray means, or the effects of certain drugs on your ability to operate a car. It's a fun way to make a living because you're always learning.
That's a very good point. It's always something new.
Right,
It's never
right.
a repeat. It's
Right.
never, and you're always often on your feet. It's not something where you're sitting behind your desk too much. You are when you're preparing for trial, but during trial, during depositions, during discovery, you're often on your feet and moving around.
You got to learn. You got to learn it. You got to learn it. You have to expose yourself to a lot. You have to read a lot. You always have to Google things now. Thankfully for that, that's around. That wasn't around when I first started doing this.
Right.
You're always learning, and every trial is different. I mean, you think there are only so many ways you could steal someone's money, but there are thousands of them.
Let's talk a little bit more about Toledo, because right now we're on a break and we have to go back to the defense's case, so it'll be a defense witness next. But we want to play a clip of a victim of a robbery that Toledo was involved in. Given the fact that Toledo had these gang affiliations and that type of a background, do you think that that's another issue that the defense is going to have to overcome in dealing with this death penalty part of the case?
Yeah, that's a big one. It's really dislikable to me as a defense attorney, because that's in New York, those are what are called Molyneux rulings, and that means it's evidence of someone's uncharged crime. It's got nothing to do with what he's charged with today. It's something the person did in the past, and the DAs are going to use this to show his intent or his lack of mistake. But that's a legal argument. But the real reason is to show the defendant's propensity towards being a bad guy.
Yeah.
I mean, this is very prejudicial. This is the kind of evidence that drives defense attorneys nuts. You try every possible way to keep it out of the trial. You try to minimize it when it does come out. But, you know, at the end of the day, the jury heard it. No matter how you try to spin it or play it or argue it away, you know, the horse left the barn.
And some of it's pretty terrible. We're going to play that for you right now. This is going to be the testimony of Eric Preolini, who was a victim of a robbery that Toledo was involved in. And then when we come back, Aaron Keller will be here in the hosting chair. Russ has to leave, as do I. But we want to thank Russ again. You were really wonderful insights into the criminal defense attorney's mind, and I know that our audience appreciates it. We'll take you to those clips of the victim of that robbery, and we will be back with live testimony as soon as we can.
Thanks for